Hello and welcome everyone. Our today's lecture is law for accounting. Specifically, any idea why law for accounting is important?
Um,
What is it all about? When I'm sorry to interrupt you guys. Basically, when if you look at many organizations don't offer laws. Instead, they offer mercantile law or business law or something else. But law for accounting, it is similar, but why it is important? Any idea? Anyone? Andrea or Haresh? Anyone?
may I say, and thanks. I My understanding is that specifically for the work that in within the accounting world, uh, that there is historical scenarios where it has evolved into creative accounting, which isn't unlawful, but it doesn't present the financial information in a true and fair view, which is the first principle of
Okay,
financial reports.
that's spot on. That's correct. So, Andrea, any idea about?
Yes, I agree. There are so many cases when companies distorted their profits, losses, and so ended up in court, and yeah, that affected. Obviously,
Yeah, that's correct.
that's the regulations that I guess we're going to be learning about in this unit.
Yeah, that's correct. Anyway, so welcome today's lecture, Law of Accounting. My name is Yasir, as I said, and uh, Law of Accounting specifically focusing on understanding the elements of law affecting commercial practice. Okay, so in this session we will discuss the aspects of legal frameworks that playing a significant role in shaping and regulating commercial activities. Commercial practice involves a wide range of transactions, contracts, and interaction that require a solid understanding of the legal landscape. So, in the realm of accounting, it is imperative of a grasp the legal elements and influence financial practices, reporting, and compliance. Uh, whether it can be contract law, corporate law, or regulatory framework. Each aspect contributes to the you know uh, have own rules that govern commercial operations throughout. This course, we will explore key legal concepts, landmark cases, and their practical implications on accounting practices. So here it's a type of law. A law can broadly be categorized into two main types, public law and private law. So public law, constitutional law, this branch focuses on constitutional law and contract, tort, property, trust, family, you know. Uh, Constitutional law, this branch focuses on the principles and structures of government, defining the powers and duties of different entities within a state. In other hand, administrative law concerned with the actions and decisions of administrative agencies, ensuring they adhere to legal principles and standards. Uh, Criminal law, pertains to offenses against the state, defining crimes, specifying punishments, and regulating the investigation and prosecution of individuals accused of committing crimes. Okay. So, private or civil law, contract, tort, property, trust, family law, all go through quickly. Contract law governs agreement and contracts between individuals or entities, specifying the obligations and right of the parties involved. Tort law deals with the civil wrongs such as negligence, intentional harm, or that remedies for individuals who have suffered harm. Property law obviously focuses on the ownership and use of property, including real estate and personal possessions. Trust laws governs the relationship where one party holds and manages assets for the benefit of another's. Then family law encompasses legal matters related to family relationships, including marriage, divorce, child custody, and inheritance. Uh, yes, key terminology. What is contract? Contract, explain. Anybody have any idea about what is contract?
I believe contract is an agreement on both parties who mutually have an understanding that they are going into some kind of trade or some kind of acceptance of dealings, which will each party will be obliged to carry out or to do in order to complete the deal.
That's correct. It must be in writing or can be verbal as well.
Both, it can be either or both,
Yes,
or you can have a third party involved to carry out that administration.
yes. So contract is fundamentally a promise that holds legal weight. It is an agreement between two or more parties where one party make an offer and the other accepts, establishing a mutual understanding. Contracts can involve promises to do something or refrain from doing something, and for them to be valid, they require the mutual assets of the involved parties. So there are 7 elements of contracts. Offers, the initial proposal or expression of willingness to enter into an agreement, then acceptance, agreement to the terms of the offer, meeting of the minds, both parties understand and agree to the terms without any understandings. Then considerations, uh, consideration, something of value exchange between the parties, often money, goods, or services. Then we talk about capacity, the legal and mental ability of the parties to enter into a contract. Legality, uh, the purpose and terms of the contract, must not violate the law. So sometimes a written documents, while not always necessary, as I said, verbal or as you said, third party or written contract. So some contracts must be in writing to be enforceable, especially for certain types of transactions. So here there are examples of contract: employment contract, lease agreement, insurance agreement, financial agreements. So employment contracts, specifically terms of employment, rules, responsibilities, and compensation. When we talk about lease agreement, outline terms of renting property, including rent, duration, and responsibilities of both parties. Then insurance agreements define the terms and conditions of an insurance policy. Then financial agreements, various contracts related to financial transactions, for example, loans and investments. Okay. Contract law offer an offer is a clear and defined, definite proposal, as I explained above, made by one party to another expressing a willingness to enter into a contract on specific term. Then agreement is the mutual consent between parties to the terms of an often of an offer, creating a meeting of the minds and forming the basis of contract. Acceptance uh, occurs when the offeree agrees to the terms of the offer, creating a binding contract between the parties. Considerations is something of value exchange between parties of or after money, goods, or often money, goods, or services, forming the basis of contractual relationships. Intention to create legal relations. Both parties must intend for the agreement to be legally binding for a contract to be valid. Uh, then we talk about terms or the specific conditions and details outlined in a contract establishing the right and obligations of the parties involved. Uh, types types contracts can be categorized in various type, such as uh, 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 such as bilateral, executed, executory contracts, implied, unilateral. So exclusion clauses limit to exclude the liability of one or both parties in certain situations, defining the scope of contractual categories. Then talking about common law rules, legal principle developed through court decisions rather than statutes guiding the interpretation and enforcement of contracts. Statutory rules and regulation established by legislative bodies influencing the creation and enforcement of contracts. Uh, Here, Unfair Contract Terms Act 1977, uh, legislation regulating the use of exclusion clauses and terms in contracts to prevent unfairness and protect consumers. So, unfair terms in consumer contract regulations 1999, regulations aiming to protect consumers by rendering unfair terms in contract unforeseeable. And a breach occurs when one party fails to fulfill its contractual obligations. Damages and other remedies. Damages, monetary compensation awarded to the innocent party for losses suffered due to the breach of contract. Other remedies, alternative legal action such as specific performance, forcing a party to fulfill its obligations, or injunctions to address breaches or disputes beyond monetary compensation. Okay, so Trade Description Act 1968. Trade Description Act is a law that aims to prevent businesses or sale people from deceiving consumers. It makes it illegal to sell a product or services based on false information. The purpose of this law is to ensure that businesses are truthful about what they offer, preventing them from misleading consumers into spending money on something that does not match the description provided. Uh, Essentially, it promotes honesty and transparency in businesses practices, protecting consumers from false claims and deceptive practices. Anybody knows about not fit for purpose?
Yes, I'm aware.
Yeah, you know about fit for, it is kind of, I believe that it is kind of that as well, not fit for purpose. If they lie to you, they said, oh, this is for this, but when
It's
you,
representation of
yes, yes,
goods and services or any other, even the contract could be a misrepresentation of what was agreed initially.
yes, that's correct. Uh, you okay, Andrea? You got it?
Yes, yeah, good.
Okay,
All
okay.
makes sense. That's fine.
Okay, so then is Trade Descriptions Act 1968. Uh, where is go? So Trade Descriptions Act 1968, the Trade Description Act 68 is a law that aims to prevent businesses or salesperson for, and then Unfair Contract Terms Act 1977. Uh, the Unfair Contract Terms Act 1977 is a law that uh, uh, regulates contracts to ensure fairness. It focuses on limiting the ways in which can party can avoid responsibility through the use of exclusion clauses or disclaimers. So these clauses often appear in contracts and attempt in limited liability, but the UCTA or Unfair Contract Terms Act their effectiveness. So the law applies to exclusion terms in various contracts, including notices that being contractual obligations into existence by doing so. So the UCTA promotes fairness in contractual relationships, preventing one party from easily escaping their responsibilities.
So would this include like the small print type of thing when we all sort of talk about generally? Would that be like things that?
Pardon me, please. Just your voice
So
is.
the unfair contract terms, for example, if the companies include any of these, like a small print, what we
Yes,
call,
yes, of
that's
course.
exactly what it is, right?
Yeah, that's correct.
Mm-hmm.
Exactly.
Okay. Thanks.
So unfair terms in consumer contract regulations, 1999. So the unfair terms in consumer contracts regulations 1999 is a law in the UK that originated from an EU directive. So its purpose is to safeguard consumers from unfair terms in contracts. Uh, I don't know whether it still applies or not. Okay, after EU because they have their own laws and UK separate from them. So they have their own. They are. I heard that they are doing some changes. Okay.
Yes, you're
Yeah.
right. I read. So
Yes.
as a result,
Yes.
this country, the UK government, will no longer
Yeah.
uh, have EU uh, terms and regulations.
So,
However, they will adopt these terms within our own statutory regulations and laws. So
and
they will foster those.
they will adopt for a certain periods. I think so. They're working on it as well. Same
Yes,
as that employment law. They are doing some changes on employment law. You know.
yes. So working directive is also being adopted since last year. So to be in line,
Yeah.
not just with European uh, 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 laws, but on a more larger scale, international platform,
Okay.
so that there's consistency.
Yeah, that's correct. That's correct. So I think so they need to update few things, but I think so they will do later, not now.
For our assignment, do we still use these
Yeah, you will use
as
still, the
references?
same material and same books and same. There's no changes so far in IFA material or IFA books or that they haven't said anything yet.
Okay, it's just that our employers
Yeah,
expect us to be.
as you said, and as far as I know, they will adopt, I think so, till end of 2025,
Yeah,
something like that. I'm
yeah,
not sure, but they will adopt for a certain period. Okay.
yeah.
So the law also prevent terms that attempt to take away a consumer's legal rights. In a sense, it ensures that consumer contracts are fair and protect individuals from unfair practices by businesses. I was. So here, contract law is component of the law of obligations, which is itself as element of a civil law. A contract is an agreement entered into voluntarily by one or more persons, legal entities. So basically, is the law of contract has evolved through judicial decisions over the years to regulate business practices. Its primary goals are to minimize conflicts and ensure that businesses transactions occur in a formal and lawful manner. So the components of contract law includes uh, formations, uh, 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 this pertains to how contracts are created, exploring the process by which individuals from legally binding agreements. It addresses what elements are necessary for an agreement to operate as a contract. So then it's privity of contract. This discuss to whom contractual obligations are owned. It delves into the parties involved and their roles in the contractual relationships. Then constructions. This aspects deals here. Can you see my screen as well? Because it's two
Yeah.
Yes, yes. Yep.
Yeah, on my laptop, there are two different screens. I can see two together, so I don't know whether you can. For you guys, it's this screen, so you can see clearly everything. There's no issue.
No issue.
No, no
Okay,
issue.
that's good. So privity of contract, exactly who are contractual, obligations on to. So then constructions, uh, this aspect deals with the types of obligations, basically what kind of obligations can be included in a contract. It explores the nature of promises and commitments within the agreement. So mitigating factors, it examines conditions under which a contract might be avoid or voidable. So this includes circumstances that could invalidate or allow for the annulment of contract. Discharge of obligations. What point are the parties free from their contractual obligations? Uh, Basically, this discuss when the parties involved are released from their contractual obligations. It explores the point at which the agreed upon responsibilities are considered fulfilled. Then remedies. This section covers the available legal remedies in case of contractual dispute. It outlines the options of parties seeking a resolution through legal means. Here is a video. If you want to watch, you can see that what is contract. So it's just a simple definition in this video, but so understanding contracts, basically a video resource explaining the concept of contract. So this aim is I'll just let me uh, can you see that?
Yes.
Yes, I'll just will listen
Yes.
this quickly.
For ranting on, being so boring.
Yeah, just quickly.
Contracts are everywhere, not just some huge formal agreement between large corporations where one is going to buy the other, so on. Although that's what something like that looks like. But as a matter of fact, it's everywhere. You go through them, I don't know how many times in the course of a day. You go into a parking garage, they give you a stub. Now, that's a contract. They're going to look after your car, more or less, and you're going to pay them. You walk into your dry cleaners and you drop off your suit, and the person behind the desks gives you a receipt. Well, that's important because that's how they're going to know which suit is yours. But that receipt is also a contract. And even if there wasn't a receipt, you're dropping it off there and coming back a couple of days later and picking up the suit. Well, they expect to get paid and you expect to pay them. That's a contract. You walk into a restaurant, you order the steak and chips and everything else, and then you get the check and you pay it. You can't just say, well, that's very nice. Thank you very much for dinner. See you tomorrow. Understood between you was they're going to feed you and you're going to pay them. And so it goes. But it gets even less formal than that. I live in New England and we have a lot of snowstorms in the winter. So what happens? It snows and a bunch of local kids come, knock on your door and say, sir, can we shovel out your driveway and your walkway and so on? How much? $20. Okay, so they do it and then they knock on the door and they have a contract with you. You owe them $20. They didn't do that as a favor. Now it gets more complicated. You're out of town and it snows. And while you're out of town, they come and they shovel out your driveway and do all that. And when you come back and they say, $20, please. Well, do you have a contract for that or not? We'll find out later whether you do or not. And what if it snows the way it did a couple of years ago, 18 inches? And they say, well, you know, we had a lot of work to do, and they really did. This time you owe us $30. You owe them $30? All that is something we're going to try to understand. Now, you might ask, why do we have a MOOC on this? Why am I asking you to join me for really quite a number of sessions and quite a lot of work, your work, my work, on the subject of contracts? One thing I'm going to tell you, I'm not going to turn you into lawyers. I'm not going to teach you how to draft a contract or deal with a situation where somebody sues you or claims. That's not what I'm going to do. What I'm going to do is for you to understand what's going on as you go through your lives in a jungle, or maybe not a jungle, a forest. It's not so unfriendly, of contracts. It's as if I were offering to teach you a course on the internal combustion engine. Now, this wouldn't be a course on how to fix your car when it breaks down or doesn't break down, but to know what's going on under the hood. So if your service station then tells you it's the transmission and that's going to cost you $1,500, you know what the transmission is, and you know whether it kind of makes sense for that to cost you $1,500. In other words, what I'd like to do when you're through with this is for you to understand this part of your environment.
Yes. Hello?
Hi, Yazid.
Yeah, so where's mine gone?
We can still see the presentation slides.
Can you see my slides still?
Yes, it's frozen with
Yeah,
right
can you
now
see now?
checked in.
Yeah, it's okay now.
Yeah.
Yeah, I think so. It's a very good explanation, that definition, it was definition, but again, that there was two kind of mainly written and, verbal contract, as he said, kids comes and knock your door and asked for, that can we clean your, doorway, and they ask you to $20. So I think so that you understand that what contract is. Okay.
Yeah.
Exactly.
Yeah.
So what is contract law and what does it aims to do? Contract law serves to establish a legal framework for parties. Hi, Arvin. How are you?
Hello, I'm good, thank you.
Sorry, hi, Arvin. How are you? You okay?
Yes, I'm good. Yeah, thank
Okay,
you.
that's fine. So, contract law serves to establish a legal framework for parties engaged in contracts. So it facilitates the resolution of disputes and regulations of contractual obligations. So this majority of contracts are self-regulatory, requiring no intervention from the courts. So despite the emphasizes on contractual freedom, the courts may intervene in cases of abuse of bargaining power by one contracting party departing from the principle of absolute freedom. What is an agreement in law? So agreement law and legal definition. Agreement is the meeting of minds or mutual understanding between two or more persons about their reciprocal rights and duties regarding past or future performances. So uh, this essentially means that parties involved, reach a shared understanding about what each should do or receive. So here it is important to note that not every agreement creates a legal obligation between the parties. In other words, an agreement as a general concept may not necessarily have the legal weight to be enforced in a court of law. So you can say it's like that in accounting, what is difference between offer and quotation? Anybody can tell me there is a quotation and there is a estimate. Hello?
I think I'll say the quotation is less binding as compared to the offer.
No. I mean estimate and quotation. So it's the same as I'm trying to link these agreement and contract. So
Okay.
estimate is not a perfectly or not 100%.
Yes.
Am I right, Andrea or Harsh or anyone if can?
Yeah,
Yes,
you are
correct.
right.
Yeah. But quotation cannot be changed. Is that right?
Yes, I agree with, yes.
Yes.
It is something that you should go by
Yes.
going forwards. That once you quote something that it's
Yeah,
binding.
that's so same agreement and contract. Agreement is not legally binding, but contract is. Okay. So moving now moving on to the context of agreement in contracts, it's important to distinguish between agreement and contract. Agreement in the broader sense encompasses any understanding or agreement between two or more parties. Okay, but on the other hand, contract represents a specific type of agreement that based on its terms and elements. Here, that is like in legally binding and enforceable in court of law. So holds legal binding and enforceable status in a court of law. So therefore, while all contracts are agreements, but not all agreements qualify as contracts due to the necessary legal criteria. Is that right? Clear?
Yes.
So example of standards form contracts can include unilateral agreement. So here he is talking about type of contracts, unilateral and bilateral agreements. Agreements. We will discuss specific types of contracts. First, a unilateral agreement refers to a contract where an offer commits to making a payment after after a specific act occur. An example to illustrate this concept is an insurance policy contract. In such contracts, the promise to pay is uh, con- uh, contingent upon the occurrence of specific events, making it partially unilateral. So, on the other hand, bilateral agreement, also known as a clearing trade or side deal, involves an agreement between parties or states with the aim of maintaining, yeah, maintaining trade balance. So the nature and complexity of bilateral agreement can vary based on factors such as the type of agreements, its scope, and the countries involved. It's worth nothing that finalizing bilateral agreement may take sometimes due to the uh, negotiable and considerations involved in achieving mutually beneficial arrangements. Agreement versus contract is just again repeating agreement and informal agreement between two or more parties that is not legally enforceable. uh, Validity, it does not require a written form. Validity is based on mutual acceptance by all parties involved. Then consideration, no consideration is required. Legal effect, agreement lacking the necessary elements of a contract holds no legal weight. So if we talk about contract, uh, a formal arrangement between two or more parties that is legally enforceable. Validity, mutual acceptance is crucial, and for some specific contracts, for example, involving land and taking more than a year to complete, a written form may be required. Then consideration, yes, it is necessary for a contract. Then legal effect, contract legally binding and its terms may be enforceable in a court of law. So here is again talking about unilateral and bilateral contracts. Differences involves parties. Unilateral contract, only one party is obliged to fulfill the agreement. Bilateral contract, both parties are legal accountable for honoring the agreements. So then involved parties, both parties form of reimbursement. uh, uh, Unilateral involves reward for the party fulfilling the agreement, but in bilateral contract, typically there are no rewards, but prepayments may be involved. Then we talk about time frames. In unilateral, no strict time frames. The promises can extend the period, but in bilateral contract involves agreed upon deadlines. Then activeness of the contracts, unilateral contract becomes active upon the promisor delivery, but in bilateral contract becomes active upon signing the agreement. Okay. So again, he's talking about repeating offer, agreement, acceptance, and consideration and intention to create legal. We just already discussed initially. So explain the principle of agency and their impact on businesses practices. So any idea or any comments on this? Okay, their corporate governance, the law of agency in business law deals with how people work together when one person, known as the agent, does things on behalf of another. So called the principle to create legal connections within a third party. This is really important in how companies are managed, especially when there is a split between the people who own the company and those who control it. So agency theory is a part of the bigger topic of corporate governance, which is that part of how companies are run, looks at the worry that directors might not always act in the best interests of the people who own shares in the company. It explores ways to stop these problems and make sure that businesses relationships work properly. Number of key terms and concepts are essential. Understanding agency theory, agent, to understand, this is someone hired by the boss or your principal or senior manager to do certain jobs. So agency is like the working relationship between the boss and the persons doing the job, relation between a principal and their agent. Agency costs, there are the expenses the principal has to pay to keep an eye on the person doing the job because they might not completely trust them. Then accountability, when someone takes on a job for the principal, they become responsible to the boss for what they do or to the principal. Separation of ownership and control, agency theory becomes important when we link about how companies are organized, especially those that are listed on the stock market. The people who own the company, shareholders, let others people, directors control it. So these directors have to act in the best interests of the shareholders, but sometimes uh, their interests, sometimes their interest might not match. So this separation can lead through conflicts between what the directors want and what the shareholders want. Agency theory and corporate governance, again, corporate agency theory help us understand how people act in the debate about how companies should be run. If we look at historical context, uh, companies used to be owned and managed by the same people. Growth and change, that companies, yeah. So as companies grew, they needed more money, so they started getting investment from many people through limited liability and stock markets. So then, delegation of control, directors who are like the managers of the company started running the businesses on behalf of the owners. Separation of goals, separation, when we talk about separation of goals, the goals of the managers might be different from what the owners want, creating problems. Changes in governance, the split between ownership and control along with different goals causes issues in running companies or agency problems. So next one is principal agent relationships, uh, and the principal agent problems, conflict of interests when the people who own the company, shareholders, and the people running it, running directors have different interests, it create a problem. So if we talk about principal, principal agent problem, this is the main issues, how companies are managed, trying to make sure directors act in the best interests of the owners. ensuring good behavior. Everyone involved in the company needs to find ways to make sure directors do what best for the owners. Then learnings from mistakes. Uh, uh, when some big companies failed because directors made bad choices, it led to discussions, reports, and laws to make sure company boards are controlled better, preventing directors from misusing their powers. So, various reports have been published and legislations have been enacted in the UK and the US, which seek to improve the control that stakeholders can exercise over the board of directors of the company. Uh, Prominent businesses scandals revealed between 1928 and 2008. So during the period of basically here, during the period of 1998 in 2008, several businesses faced ethical violations and legal sanctions due to accounting violations. So these scandal involves companies like Enron, WorldCom, Tyco International, and more. You know that these companies. So the violation including improper inflation of revenues, overstatements of earning, hiding debts, and fraudulent accounting practices. uh, these instances not only ethical violation but also led to legal consequences for for some companies. So this list is not you know exhaustive, and allegations from the period were still pending as of 2011. Additional scandals emerged, including those related to investment banking and the home lending, debacle. Next, explain the law of tort and remedies available. Uh, Understanding the law of tort and remedies, a tort is like a civil wrongdoing, a breach of a legal duty, or an infringement of a legal right that can lead to a claim for damage. For a situation to consider uh, a tort, there must be a recognized legal duty, unlike contracts where there is an agreement between parties. Tort claims can succeed even if the parties have never met before. For example, in a person injury claim from a road accident, the involved parties might not have had any previous relationship. So, if both a contract and a tort are involved, the person making the claim can choose the most suitable remedy for the situation. So, in simple terms, the law of tort deals with the civil wrongs, breaches of legal duties, or infringement of legal rights leading to claim damage. But unlike contracts, tort claims can succeed without prior relationships between parties. Contracts and tort overview. Contracts in the realm of legal agreements, damages play an important role in compensating those who have suffered harm in the context of valid contracts. Damage serve the purpose of restoring the injured party to the positions they would have occupied if the contract had been properly executed. On the other hand, a tort cause damage aim to place the injury party in the position they would have been in the wrongful act. So there are two parties under a valid contract. The amount of damage awarded in intended to put the claimant back the positions he would have been in had the contract been properly performed. So uh, it is it's important to note that there are specific time limit known as limitations periods with the legal action must be initiated. Contracts generally have a have a 6 years limitation periods from the breach, while torts usually follow a similar 6 years timelines. With personal injury cases have a shorter 3 years limitation. So main elements of tort to succeed in a tort case, certain fundamentals element must be satisfied first and foremost. So uh, m- here there must be an identifiable actions or failure to act by the defendant. So the defendant's actions must have directly caused harm to the claimant, and the courts play an important role in establishing legal liability arising from resulting damage. Importantly, for a tort claim to be successful, uh, uh, for successful, for of the loss suffered by the claimant must not too remote, meaning it must be a direct consequences of the defendant actions. So specific torts within the category of torts, various specific types exist. For example, nuisance, the tort of nuisance, for instance, involves interference with the use of enjoyment of land, and it is further divided into private and public. In a sense, trespass to land occur when there is a unauthorized entry onto someone else's land without permission. So trespass to person encompasses actions like assault, battery, and false imprisonment, negligence. Another tort is categorized by the breach of a duty to take care, requiring evidence of duty breach and resulting damage. So the neighbor principles emerge from the landmark case. Here is talking about Stevenson versus Donegal. This legal principle established a duty of care even in the absence of contractual relationship. Simply put, individuals must take responsible uh, care in their actions to prevent foreseeable harm to others who could be directly affected by those actions. So, this principle expanded the scope of duty beyond contractual obligations, particularly in cases involving in the manufacturing of goods and the duty of care owned by onto or owed to consumers. So basically, fact was Mr. Donoghue went to a cafe with a friend. The friend bought her a bottle of ginger beer with Mrs. Donoghue drank. She then discovered that there was a discomposed snail in the bottle of the epic bottle. Mrs. Donoghue found that single so upsetting that she suffered physical illness. She sued the manufacturer, so claimed that they were under a duty to see that such outside bodies did not get into the ginger beer. Obviously, they definitely had their quality department. So there was a duty on behalf of the manufacturer to take held reasonable care in manufacturer of their product. So the manufacturer owns a duty to the consumer to take responsible care to prevent injury. So assess the validity of given contracts. So in Felthaus versus Bindley, in the case of Felthaus versus Bindley, The claimant wanted to buy a house and discuss it with his nephew. So the claimant wrote a letter assuming the horse was his. If they did not hear back, the nephew did not reply and instructed the auctioneer defendant to keep the horse from the auction. So the auctioneer mistakenly sold the horse. The court held that for an acceptance to form a binding agreement, it must be clearly communicated. The nephew, even if he intended to sell, did not communicate this to his uncle. So no binding agreement was formed. So the case also introduces the postal rule and exceptions, stating that acceptance is complete when a letter is posted, even if not received. In Feldhaus versus Bentley 1863, a case illustrating contract principles, the court emphasized the importance of clear communication for a binding agreement. The postal rule exceptions was also introduced, stating that acceptance in contract is complete when a letter is posted. Then is another case law, Adams versus Lancel facts. In this case was Adams versus Lancel's 1818. The focuses was on the format. The focus is the parties sale of wool. 2 September, the defendants wrote the claimants offering to sell them certain fleeces of wool and requiring an answer is the course of post. So the defendant misdirected the letter, so the claimant did not receive it until 5th of September. Claimant posted their acceptance on the same day, but it was not received until 9 September. Meanwhile, on 8 September, the defendant not having received answer by 7th September as they had expected, sold the wool to someone else. So held the question for the court was whether a contract of sale had been entered into before 8 September when the wool was sold to the third party. So if the acceptance was effective when it arrived at the address or when the defendant saw it, there was no contract would have been made and the sale to the third party would amount to revocation of the offer. So, however, the court held that the offer had been accepted as soon as the letter had been posted. So, the defendant was therefore liable in breach of contracts. Evaluation, shareholders and auditors evaluate the implication of an agency relationship for the principal and the agent. Corporate governance, shareholders and auditor corporate governance guidelines also address the principal agent relationship between a company and its auditors. So auditor acting as agent to shareholders play an important role in corporate governance by providing an independent review of the organizational financial position. Uh, independence arise, trust and independence arise as auditor like directors have their own interests, or auditors will have their own interest and motives to consider. So like directors have their own auditor independence from the board is vital, but it creates a delicate balance as auditor need a close working relationship with the board. Shareholder questions auditor independence, leading to the introduction of tougher controls and standards to protect their interests. The cost of agency relationships, agency costs arise from the need to principals to monitor the activities of agent, and these costs can be measured in terms of money, resources, or time spent in monitoring principals bear these costs, but agents directly incur them as well. Using their time and resources for certain activities. Examples of agencies costs include providing incentive schemes and different benefit packages for director, the costs associated with the management providing annual report data such as committee activity and risk management analysis, and the cost of the principal reviewing this data. Uh, Residual loss is an additional type of agency cost that arises when directors furnish themselves with expensive assets such as uh, cars, planes, and beyond their regular, benefits packages. So these additional costs directly impact shareholders and result in a direct loss. So this loss can occur, through various actions such as meeting between directors and institutional investors, voting right as, AGM, annual general meetings, accepting takeovers, and the ultimate threats of divestment of shares. So need for corporate governance if the mechanism uh, of the market and shareholders' activities are insufficient to effectively monitor a company, regulations become necessary. Various codes of conduct and recommendations issued by government and stock exchange serve as guidelines. Although compliance with these codes is voluntary, not governed by law. So the fear of reputational damage and the threat of uh, uh, delisting from stock exchange make it challenging not to comply. So example of such codes include the UK Corporate Governance 2010 adopted by the obviously Financial Services Authority, uh, and I think so they have a different name now. If anybody can, Financial Services Authority, FCA might be Conduct Authority, and OECD.
Correct.
Sorry.
It's been split to FCA and PRA.
Yeah,
FCA, Financial Conduct Authority, PRA,
yeah, I think
Prudential
so.
Regulatory
This one replaced by a Conduct Authority. Am I right?
Yeah, but it's been split into two bodies.
Yeah, I know that. It's a provisional, I think so, if I'm not wrong.
Yeah, PRA and
Yeah,
FCA.
yeah, that's right, that's right. So then ACCA codes specifically regulations, particularly concerning directors, benefits, and the city code on takeovers further contribute to the need for effective corporate governance. So that's it for today. Here are some books for reading or references, and there are some, websites as well. So if you have any questions or any concerns, you can drop me an email at yasir@ukversity.co.uk. So in case of any emergency, I forgot my number.
Can you
Yeah,
email the
yeah, here
the
is
number?
my mobile number. You can WhatsApp me, and
Perfect, thank you.
then here is email. Just write in for you in capital so you can see. Is that clear?
That's clear.
Thank you very much.
Thank you. Thank you.
Concern, questions, issues, anything else?
I'll read the material on Moodle and I'll
Okay,
come back to you.
okay.
And we have a
And
test tomorrow.
we have
That's
a session tomorrow, right?
yeah, tomorrow same time, 2 o'clock. Might
Okay.
be sometime, because I give 2 lecture back to back. So one till 2 o'clock, two till 3 o'clock. So might be two couple of minutes or 4 or 5 minutes late, but you just wait, same as today. So, but
Perfect.
most of times I come on time, okay? 2 o'clock,
Right.
definitely 2 o'clock tomorrow. Thank you,
Okay, thank you.
everyone, and
Thank
have a
you.
good evening, and
You
bye
too.
for now. Bye.
Bye.
Bye bye.
Bye-bye. Thank
Bye.
you.